like superhuman beings with powers beyond our imaginations and achievements. Social networks have produced in us, independently of our will, new behaviors and fashionable labels. Likers, followers, haters, each from his or her smartphone or tablet, create his or her world, and the world of one can strongly affect the world of the other. This intersection of the universe resulting from several ways of thinking has the most unsuspected consequences. The main reason for this is a deliberate, conscious, planned, and recurrent manipulation of information. Many are then tormented, and some are unknowingly to several lawsuits. In this register of prosecutions, the person responsible for the offense may benefit from certain mitigating factors. This is known as the presumption of innocence. But what exactly is it? There are two ways of understanding this presumption of innocence. We will start with the simplest. What does the presumption of innocence mean? It is a guarantee to all citizens of a state, in the context of the proceedings of which they may be the victim, or of which they may be the subject of competent institutions. And I emphasize on competent institutions. It is the guarantee by these same institutions that he will not be treated otherwise than as a citizen, and could therefore not only be found guilty and treated as otherwise upon the intervention or after the intervention of a decision of this competent institution. Basically, there is no court decision on the guilt or non-guilt of an individual who is being prosecuted. He or she cannot already be treated, considered, or even qualified as guilty.
Ou même qualifié de coupable.
Acceptance received in the common register. But when we are a little more situated in the Cameroonian register, it rather gives this. The total sum of what we can and cannot do is contained in the regulations of a country. But the one that interests me here is the penal code and the guardian of the respect of the penal code. He is the public prosecutor, invested by the oath that is his, but also by the mechanism of the hierarchy that links him to ministries and institutions. But first of all, the first actor in the protection of the criminal law is the public prosecutor. He can therefore be taken in the violation of the criminal law in several ways, meaning that once he is taken, he puts in brand a certain number of mechanisms which first of all amounts to useful information. What do we mean by being usefully informed? For him, it is a matter of resorting to his subordinates, his hierarchical subordinates, who are the agents or the judicial police officers and the other experts who are sufficiently skilled to gather a certain number of elements on the facts for which he is taken. Once this information has reached his level, he now has the possibility of either bringing before the competent courts the pupils he considers that should be held responsible for their actions, or simply dismissing them. In one case, we will have an order for referral to a court of law or an order for allocation. It may happen that, due to the extreme seriousness of the case, additional measures may be required, and it is therefore possible that a file of this type will be transmitted to the office of the investigating judge. This examining magistrate will have the task of carrying out all the necessary steps, that is, expert reports, rates, researches, counter-examinations, and confrontations, with the main aim of determining the degree of responsibility or involvement of all the people whose identity has been transmitted to him. Once the investigating judge has been able to establish all these ways of responsibility according to the canons that are theirs, he will be able to put in place either an order for referral or to the competent court of judgment, or to dismiss the persons he considers not to be linked to this case. This is basically the circle that will lead from the commission of the offense to the trial judge. And once before the trial judge, he has a range of prerogatives in terms of his competence. A range of prerogatives that will allow him to know who can be heard as a presumed guilty party, as a suspect, as a defendant, or as a witness.
Comme présumé coupable, comme suspect, comme prévenu, comme témoin.
Let us recall that any person who has been summoned or heard or who has been the subject to the final decision benefits from the presumption of innocence. The suspect, the accused, or the defendant are all sheltered for a given moment, but each actor is defined according to a set of elements developed by Maître Monk. For example, when is one a suspect? One is a suspect from the moment when a certain number of reasonably objective elements link to a person to the commission of an offense or to the place where an offense was committed. One is charged when these elements have been deemed sufficiently probable to invite that person to present his defense before a court. One is warned from the moment when the elements presented by the prosecution have been received by the judge and have been judged sufficient for that person to enjoy one of the options of Article 365 of the Code of Criminal Procedure, which will ask the person to choose how he wants to answer for the acts attributed to him.
Choisir comment est-ce qu'elle veut répondre des actes qui lui sont imputés.
Like the suspect, the accused and the defendant also benefit from the presumption of innocence once these attributions are lost, and so is the presumption of innocence. But at what point do you lose it? From the moment that a final decision has been made on our guilt. If the person who is considered to be at fault from the moment there is a court decision does not benefit from the presumption of innocence because it leads to the contesting of a court decision, which is quite open to all citizens and to all justiciable who consider that the guarantees that should be his have not been sufficiently protected, notably his innocence. So, from the moment that his innocence is open to appeal, it is not therefore definitive. And if it is not final, the weight of this decision cannot yet be applied completely to his defendants or to his person deemed to have been convicted. So, the decision remains pending because it is being re-examined, the case is researched, the parties are heard again, expert opinions can be ordered again. Counter-expertise testimonies both for the prosecution of the defense, because a new proceeding will be held. The previous one is suspended because the judge who is appealed against can confirm the decision of the previous instance, just as he can affirm it. So, this decision remains suspended. It is not final, and so we understand that as long as a decision is not final, the character or guilt of the person being prosecuted cannot be fully consolidated.
Totalement consolidé.
Seen in this light, the presumption of innocence for any citizen or professional has a given lifespan that must be used carefully. In the world of social media and social networks, this legal principle deserves even more attention. But for this to happen, it is necessary to go back to the fundamentals of freedom of expression and to put one's information through the tribunal of usefulness and verifiability for information production.